Hey, good morning. Good morning, everybody. Greetings from the great state of Connecticut. I say that because I see some chatter here about the great state of North Carolina.
The center of the known universe.
The center of the known universe only if you're a know-nothing. But I love you anyhow, Mike. Welcome back to Law and Legitimacy. We had another hiatus yesterday. Mike and I are regrouping and had a miscommunication about whether I'd be back or not. But I am back. I want to give you an update on Owen Schroyer. And a request for your assistance. Owen Schroyer, as many of you know, and some will soon learn, is a personality, a talking head on Alex Jones's production InfoWars. Young guy, early 30s, and very prolific. He's right-wing. Some would call him far-right. I think he'd call himself a Christian commentator of some sort. But in any case, he was present with Jones and others on January 6th, protesting against what they believed was a stolen election. And, everybody has a right to petition for redress of grievances. Whether those grievances are real or not is an open question. And the Constitution doesn't say you only get to complain about things that other people agree are a problem. You get to pick the things that you're a problem, that you think are a problem. And that's the whole point of having free speech. So Schroyer's present on Capitol grounds. The thing turns into a riot. And he gets arrested along with hundreds, more than 1,000 other Americans for participating in the riot. His charges were entering and remaining on Capitol grounds without permission at a time when they were prohibited to be on Capitol grounds. He entered a guilty plea to that trespassery offense. And the Office of Pretrial Services in the federal system did a pre-sentencing report where they recommended a sentence of probation for Schroyer. A pre-sentencing report is a report on a person's life, their criminal history, their education, their circumstances. It's designed to provide a judge with a complete picture of the person they're sentencing. In federal law, in federal criminal law, judges impose a sentence even in the case of a plea. The parties don't agree on what the sentence will be. That's the judge's decision. So the government asked the court to sentence Schroyer to 120 days in prison. We asked for the recommendation of the professionals, the pretrial services people, to be followed probation. The judge imposed 60 days of incarceration. And in imposing it, he agreed with the government that Schroyer's speech was one of the things that Schroyer said were one of the reasons that he was sentencing him to incarceration. And we found that, and I find it still shocking, because although a court is permitted to consider relevant offense conduct in imposing a sentence, and in no other case was protected speech, that is, protected political speech, and in no other case that I can think of has that been used to justify an incarcerative period, a period of incarceration. And what am I talking about? In the government sentencing memo, the very first sentence of it refers to Owen spreading disinformation about the 2020 election. That's not a crime. They talk about Owen in the days and weeks before January 6th, encouraging people to protest. That's not a crime. That's protected. That's absolutely protected speech. On the day of January 6th, they talk about Owen marching to the Capitol chanting, "Death to tyrants, 1776. That's protected speech. Afterward, after January 6th, the government talked about Owen's online commentary, refusing to apologize for the events of January 6th, in effect, gloating over it, glorying in it. That is not prohibited. That is protected speech. So we objected to the government's consideration of speech that is protected by the First Amendment, conduct, petitioning for the redress of grievances, peacefully assembling. We objected to this sort of material being considered as relevant offense conduct for a trespassing offense. And the judge went ahead and did it anyhow. So we asked the judge to permit Owen to be released pending an appeal, because we want to take this case as far as we can. The judge denied that. We filed an emergency motion to the District of Columbia Appellate Court and asked the court to stay, the appellate court to stay the requirement that Schroyer turn himself in. The court denied that. So Monday morning, I hopped on an airplane, and on Tuesday midday, we turned Mr. Schroyer in at the Oakdale facility in Louisiana, where he will spend up to 60 days, that the period of his incarceration. I predicted by the time jail credits and all that other junk gets worked out, he'll probably do about 26 days. That's my actual prediction. I'll let you know if I'm right. And so we're taking the appeal, and we're raising funds for the appeal, and we intend to take the case all the way to the Supreme Court. And people have raised questions. Well, if he's going to have done the 60 days, isn't this now moot? No, it's not moot. It's not moot in part because in addition to the 60 days, he's got a period of supervised release thereafter. And he remains every bit as much in custody then as he would have he remains in custody in terms of his liberty being interfered with by the government, although not to the extent of being incarcerated. And we think the principle is important, and we want to get this case in front of the United States Supreme Court, because what's happened is, while Owen was wrong to trespass, and he admitted that, and he acknowledged that in his guilty plea, he wasn't wrong to express his opinions. He wasn't wrong to appear at the Capitol at all and engage in protest. He wasn't wrong to encourage Congress to not certify the election. Where he was wrong was in crossing certain lines, in trespassing. And for a trial court to say that, among the reasons you should go to prison, Mr. Schroyer, is you spread misinformation, is, in my mind, a terrifying departure from bedrock First Amendment principles. I don't know how many of you noticed just the other day, but there was a story published about China and social credit scoring. And what we've predicted here has now happened in China. You get a social credit score in China based on your online personality, based on what is able to be inferred about you, based on the sites you visit, the things you say, and your behavior online. And an algorithm created and sponsored by the Chinese Communist Party will score you based on your associations, based on your reading habits, based on what you do, where you go, and what you say. And that becomes a social utility score. Well, China is gravitating toward a digital economy where you can pay for necessities by digital means. And there are some shops, apparently, that will not take cash, that you can only use digital stuff to pay. And now there's a grocery store in China that will not permit people to buy food if their social utility score falls below a certain threshold. And I don't know, I don't have any subjective sense of how things are weighted, but according to the story, a score of less than 550 means you can't buy food at a certain grocery store. Now, as the algorithmic state gathers steam, and as digital currencies become the norm, and as companies refuse to take cash, will there come a point in more places, including in Western countries, where unless you have a certain score, you're not going to be permitted to purchase items necessary to survive? China is the test case, the proof case for this. And at least in some grocery stores, you cannot purchase food if your score falls below a certain point. And so this is among the reasons why. Point value. These are among the reasons why I'm so hot to trot on Owen's case. His speech has now been used to calibrate what punishment he should get for trespass. And normally, a trespassing offense doesn't reflect your political views, or your political views aren't relevant in determining how much a person should be punished. But in this case, Judge Timothy J. Kelly did so, and the D.C. Circuit Court of Appeals appears to be prepared to agree with Kelly in rejecting our emergency motion. They said we hadn't shown a substantial likelihood of success on the merits. So we intend to take Owen's case all the way to the U.S. Supreme Court. We think First Amendment issues are issues that's a hill we choose to die on. I choose to die on. And so we would appreciate your considering supporting Owen's Legal Defense Fund. Spoiler alert, yes, most of those funds go to me. So this is a direct appeal for your support. But if you believe in the First Amendment, keep an eye on the Owen Schroyer case. He fully complied with conditions of release. There's been a lot of misinformation spread in the mainstream media about this. Owen Schroyer is a First Amendment crusader, and we're asking for your support to help wage that crusade. Enough about that. Mike turns out to be a prophet in his own town, and I'm going to let him toot his own horn. He would have told you this was coming, and I was like, what? Are you serious? States attorney generals have sued Meta, formerly Facebook and Instagram, basically claiming that these social media entities are harming kids, harming adolescents, that the algorithms they use to promote communication as between these young people harm them. And I have some reservations about this, but Mike, this is an issue that you brought to my attention and really fought for on this platform. Tell us your view of the suit, and then I want to ask you some questions because I have concerns about a hidden fist inside this velvet glove.
Yeah, so I think that I've kind of maybe tipped my hand a bit with the description there, asking whether the proposed remedy is meaningful. What I brought on the screen here is the lawsuit. So I understand, according to that Wall Street Journal article that I just had on the screen, that there are actually two lawsuits, Norm, that were filed, I believe, on the same day. One originates in D.C., the other originates in California. The California suit is the one that I have here on the screen, and there are 33 states attorneys general included in this, and then the other 8 are joined in the DC, or I think it may have originated out of Tennessee, but it was filed in a DC court, I believe. So, but what we have is pretty robust, right? This document it says there are 233 pages, and so it's obviously not given me enough time to go through. But I think that what I'm going to assume, based on if we skip down to just claims for relief right here on page 145, if one skips down to that where the complaint begins to allege certain claims for relief, you get a sense of exactly, I guess, what remedies may come out of this. And to me, it will largely be a combination of injunctive or equitable relief, right? Something the court orders that Meta do or stop doing. And then mostly will be fines, because this is largely based on violation of the Federal Child Online Privacy Act, or what's known as COPPA, that guards young people under the age of 13 and gives affirmative obligations of online protections to internet service companies, social media platforms, and providers. And then there's all these, every single state's unfair and deceptive trade practices statute, the consumer fraud protection statutes, all these various things are alleged one by one, just successively. And so, Norm, I don't know how substantive this case ultimately will be. I'll bring up on the screen something that the first Wall Street Journal makes reference back to, which is this 2021 article from the Wall Street Journal, which is titled "Facebook Knows Instagram is Toxic for Teen Girls. Company Documents Show Its Own In-Depth Research Shows a Significant Teen Mental Health Issue That Facebook Plays Down in Public." I guess my issue with this, Norm, is that I want to be very clear, and I've been pretty honest about where I stand on this stuff, because I do think that there is something wrong with our interaction and our day-to-day reliance and involvement with social media. But I don't know that it's just this, like we're talking about young people and protecting kids. And I know I've sort of advocated for some sort of age of majority, but I see these things as more akin to, the purchase of, beverage alcohol or nicotine or anything like that are federal agencies responsible for what we consider to be, food and other things that go into the human body. This is just sort of like a sort of a transactional look at, whether the COPPA obligations are being honored by Facebook and Instagram to the extent they're supposed to be, right? You guys say you're doing these things to protect privacy. You're saying you're doing these things to guard young people, but are you really doing it? My problem is that this stuff is sort of a genie out of the bottle, right? It like Pandora's box with the algorithms, and our engagement with social media platforms has already, it's not going to be shoved back into a corner somewhere.
Let me react to that, because let me tell you what bothers me. I mean, I understand the state's interest in assuring minimal standards of public health, and I understand limiting access to alcohol to people above a certain age, at least the legal purchase of it. I even understand the similar situation with nicotine. Both alcohol and nicotine are highly addictive substances. Young people who use them may acquire lifelong health consequences, and they're not in a position to make judgments necessary to determine what's in their own best interest. Social media, some argue, shares with alcohol and nicotine a highly addictive quality, and that is because of the nature of the adolescent or pre-adolescent mind and the cues that electronic communications give. It may be that young people are vulnerable to manipulation and an addiction of a sort in ways that are inconsistent with their long-term flourishing as human beings. And that analogy has some power. But here's what troubles me about it: what the algorithms deliver content. And we've got it seems to me that this is opening a door to something like content-based censorship, because they're not saying that you can't have access to social media at all. They're saying that social media access needs to be limited. And if it needs to be limited, who's going to do the limiting? And isn't it the role of families to decide what their children should be exposed to in terms of ideas, and not the role of the state? And what I find troubling about the Meta suits and the Instagram suits is the fact that we've got states' attorney generals asserting a broad police power that will encroach upon the ability of families to decide what their children should be exposed to. And echoing the Schroer commentary of moments ago, are we going to have states' attorney generals using this sort of litigation to say that what we deem to be misinformation is an unfair trade practice, and therefore you can only express yourself in ways that the state approves? And I'd be interested in your reaction to that, Mike, because
I just don't think I think that you and I fundamentally approach this issue from different vantage points.
That's why I'm raising this. Yeah.
Well, because if I can just, I guess, repeat back what I'm hearing from you, the way that you're approaching this is that you are projecting your voice into the ether, right? Into the platform, into the public sphere, whatever you want to call it. I'm saying that social media platforms are an incursion on one's experience. Like it is a constant flow and a constant manipulation of the way that information and data is organized and filtered and triaged for consumption. And younger people inherently have less analytical ability along these lines. Now, technical ability in terms of using tech, we all know that the trite sort of observation there is that young people know tech better than older people. And while that's true, it takes the likes of you and me to discuss these things in a way that sort of bridges a gap to say, hey, yeah, I acknowledge that when I was 13 or 14 or 15, I would have no way of contextualizing any of the information that's being promoted in news.
Do we want states saying that this form of information is too toxic for kids, and therefore the state's going to limit it?
It's not just the information. What I'm saying is that everything is this sort of grid, right? There is the whatever you happen upon if you click on a video, what I referred to the other day as ephemeral content. That's not my phrase. That's Dr. Epstein that appeared on Timcast IRL and has done real research and is compiling data-driven objective research to show the way that these big social media companies are using their algorithms to affect certain outcomes and basically turn on and off certain levers of society when it comes to communication and consumption of information, and then also to affect behavior patterns and the way that conversations occur in what we perceive to be the public sphere in this online internet scape, right? And what I'm saying is that this lawsuit is just sort of a red herring to me. Sure, they're not in line with a lot of the promises that they've made pursuant to whatever federal laws and whatever state laws were ratified, in years past, right? Sure. So what? It's not going to solve the problem that we're talking about. When Vivek Ramaswamy says that there is a sort of a fulfillment problem within young people, that there, and this lawsuit makes mention of the elevated suicide rates and this dissonance between one's individual.
I don't want government solving that.
I'm not saying that I want government solving it, but I am saying that there is a problem that needs to be identified for what it is, not for the things that are surrounding it and may look like low-hanging fruit and existing legal regimes to pull on, right? We're not even we haven't even fully identified what the hell is wrong with our engagement with the online space. No one has said in consolidated and concise terms what the hell what the algorithm is. That is the secret sauce to how these companies keep people on their platform.
You're right about that. And I think the marketplace of ideas, and it may be the marketplace of ideas can't solve this because of the asymmetry and the power that social media companies have. That may be the case. But the notion that I'm going to give government the ability to manage that. I
am inherently suspicious and skeptical of bureaucracy's ability to do anything effectively to solve a long-term public good, right? I talked about that with Mark Meckler while you were gone that Friday, Norm, that perhaps there was a time in our history when Americans looked at American institutions with sort of the reverence and ascribed that sense of legitimacy to these institutions, and these institutions were formed for to advance certain public policy objectives. But these institutions, especially administrative agencies, have largely outlived their useful life because they were formed during an acute era of something specific that needed to be addressed. Now they just continue to try and justify their own existence without trying to either get out of the way and dissolve, right, and return that money and whatever back to the public, or actually solve problems that are identified. And right now we have not even fully conceptualized in basic terms what our problem is as a society as it relates to social media. And it to me is something transcendent. It's something
I hear you.
And it's on a God level.
It's something we ought to be focusing on, and we probably agree that this suit is a misstep. It certainly bothers, the notion. I just think we're close to social utility scoring, and we're close to what China is doing. And I view this litigation as opening that door in unintended ways. But let's focus more on this in time to come. Let's pivot right now, though, so we try to get
the headline, right? Let's do the headline.
What's that?
This one.
Oh, well, yeah. So I wanted to talk a little bit about Trump, both in Colorado, in the Section 3 of the 14th Amendment issue that we talked about before. But I also want to wrap on Judge Engoron's knuckles a little bit in New York. Let me do the low-hanging fruit piece before we pivot to Colorado. What the hell's the matter with Judge Engoron? I mean, he's got a court trial. And he's issuing a gag order against Donald Trump so that Donald Trump doesn't pick on court staff. If ever there were a bully in a robe who needs his knuckles wrapped, it's Judge Engoron. That is not what a gag order has ever been used for. Gag orders are typically used to assure that the administration of justice remains possible. And the gag orders are imposed to prevent undue prejudice as to jurors. If Donald Trump wants to pick on the judge's staff and say that, one of his clerks is having a relationship with Chuck Schumer, and that's wrong, then let the staff member sue Donald Trump for defamation. But for the court to say, I'm going to impose a sanction, in the first 5,000, now 10,000. Watch out, it's going to get worse, because you can't say bad things about the court staff under guise of a gag order is repulsive. And Judge Engoron is a bully in a robe. And I stand with Donald Trump on this one. I'm not going to address the merits of his claims as to the court staff. I could care less whether she's banging Dumbo the clown or Dumbo's twin brother, Chuck Schumer. It doesn't matter to me. What matters to me is we've got some robe-wearing jackass basically saying to Trump, you can't pick on my staff or I'm going to fine you I'm going to fine you financially, and dressing it up as a way of protecting the administration of justice. The right to speech is sacrosanct. The remedy for violations of speech are through defamation or other claims. Imposition of a gag order is meant to protect the functioning of the jury system. There shouldn't be a gag order in a court trial, period. Judge Engoron is way over the line. Shame on you, Judge. If you want to engage in bullying, go work for organized crime and get rid of the robe.
Check this. ACLU sides with Trump, argues January 6th case gag order is unconstitutional.
Well, good.
Strange bedfellow.
Well, I think it is, and I think we're in an era where there seems to be a hunger to regulate speech. And we said before at the first of the year, among the issues we'd be watching in the course of this year is the gathering desire, the pent-up implicit demand for limitations on speech, including hate speech. And, Donald Trump is a man who's very polarizing, easy to hate. And, if you want to make a case for gag orders, he would obviously be the test case. It's good to see the ACLU siding with Trump. Gag orders are inherently suspicious. And if he engages in tampering with a juror, that's another thing. If he engages in threatening, there are laws against that. But to silence him because you don't like what he's saying, or you have some abstract fear that this could ultimately affect the jury, that's a little bit much. Let's pivot to Anderson versus Trump, the Colorado case. Recall earlier we talked about the law review article. It's saying that Section 3 of the 14th Amendment created a responsibility among those who'd sworn an oath to uphold the Constitution to make decisions about whether a candidate could be eligible to run for office, to appear on a ballot, if that individual engaged in insurrection or aided and supported insurrection. And the authors of the article concluded that this was not something that required judicial findings, that a local Secretary of State could reach that conclusion and could keep, let's say, Donald Trump off the ballot if that in that Secretary of State's judgment, if Trump had engaged in insurrection or provided aid and support to those who had engaged in insurrection. Section 3 of the 14th Amendment says that if an official who, having previously sworn an oath to the Constitution to protect and defend and uphold the Constitution, engages in this conduct, they can't be a federal official again. Well, some state official was going to draw the line and create a test case out of it. And so here we have it in Colorado. The Colorado Secretary of State is apparently refusing to put Trump's name on the ballot for presidential primaries as a result of the Secretary of State's conclusion that Trump engaged in insurrection on January 6th or aided and supported or provided aid and comfort to those who did. And Trump has been trying to throw that out, get that thrown out of court on the grounds that this requires something other than an ad hoc administrative determination by a Secretary of State. The trial judge has said no. And now the case is set, I believe, for a court trial next week.
October 30th is what I understand. And this is, they've lobbed what I felt were a series of convincing and compelling arguments. I want to skip down to just, and I told you before we got on, Norm, that in reading this order from the court, it really felt as though the judge was doing backflips to try and find a way to keep the case in her courtroom. And page 10 references, and I'm not cherry picking, but this is just an example of that. So Trump
against cherries. I like cherries. I want you to cherry pick. Find the sweet part here so we can get rid of it.
Just to make sure this is set up properly, this case is not filed against Donald Trump. Donald Trump is intervening in supporting the defendant in this case, which is the Colorado Secretary of State. So the petitioners have filed a lawsuit against the Colorado Secretary of State, seeking to prevent the Secretary of State from allowing Trump's name to appear on the ballot. Trump has intervened and also is supporting every one of these motions to dismiss, of which there are many, right? They're on constitutional grounds, on I guess what we would consider to be sort of that administrative versus ministerial grounds. But a 12b6, a motion to dismiss, we've said this before, but the standard is necessarily that is a court is required to assess that as a matter of law, there's nothing there to decide, right? That the non-moving party is entitled to, or the moving party is entitled to just a summary conclusion of the case at that preliminary stage. And I want to be fair to say that the more a non-moving party argues with a court, or a moving party argues with a court to say there is no, dispute as a material fact, the more words and the more arguments one makes, you are necessarily putting more and more into the record over which there might be a dispute, therefore invalidating your move to dismiss, right? In this case, it seems to be the opposite, that the non-moving party or that the Secretary of State and Trump as the intervener are making a ton of arguments to the contrary to say, no, this shouldn't go forward, or we are the moving party. So I got that mixed up. But yes, they are moving to dismiss. And in this case, that is exactly what's happened, is that it's almost like the sheer weight of all of the legal arguments made. If you just distance yourself from the substance thereof, it's like, you guys are saying a lot of words. Is there not really a factual dispute as to any of this? Is there really nothing here for us to argue over? And from that perspective, I know it's really reductive, but here's what I wanted to cherry pick. Here it is. In analyzing a couple of the cases that Trump's team relied on to say that, hey, this shouldn't be in your court, you don't have jurisdiction. They say, quote, first, the court says this. First, the court holds that Frazier and Kuhn are not controlling in the circumstance where constitutional issue is not a separate claim. Both of those cases addressed whether the petitioner could bring a separate claim challenging the constitutionality of the election code, just talking about Colorado's. Petitioners have asserted no such claim in this case. While the court agrees with intervener Trump that petitioner's claim relies heavily on the 14th Amendment of the United States Constitution, intervener Trump does not cite any case law that suggests that a CRS, and that's a Colorado state election law claim, cannot have constitutional implications. So effectively what this judge is saying here is that because there is nothing saying that we can't, we get to disregard any of your constitutional arguments to say that this is a federal issue and is not ripe for this courtroom, right? That is in plain English. You haven't said you can't. You haven't said the word. You haven't cited any precedent to say that we can't, rather than saying there is precedent saying that it's inappropriate here. Like, oh no, well, there's nothing saying that we specifically can't have a constitutional issue embedded in this. Which, by the way, the constitutional issue norm is the First Amendment. There was an anti-SLAPP motion involved with this as a primary consideration for the court. So the constitutional issue that underlies this is Trump's right to speech, period. If he's removed from the ballot, the implication is necessarily that he is muzzled in the state of Colorado. So the court, in saying all of this, is also saying that, well, that may be the case, but we still have the authority to hear all of that out, which is absurd. But beyond that, the standard here is that there has to be some sort of ruling that someone would be unlawfully placed. The court is saying in the standards that if the Secretary of State might do something unlawful, right? Like put somebody who's not allowed to be on the ballot, that the claim is ripe. That's fine, except there has been no formal ruling norm, as you know.
That's the point. The point of the law review article was that each state official with who's sworn an oath to uphold the Constitution can make the decision themselves that Trump engaged in insurrection or aid and comfort to insurrectionists. Thus, the claim would be that the Secretary of State retains the right to say, no, you can't do it, Donald, much like you can't run if you're 34 rather than 35. And I'm not sure that those two claims are the same. Age is supported by a document that's always admissible, and about claims of a person's age are supported by a document that's always admissible and about which there's very little disagreement, a person's birth certificate. You're either 35 or you're not. whether you engaged in insurrection or not calls for a series of judgments that are not self-executing.
Well,
And so
in Colorado's law, Norm, Colorado's law actually makes a more specific phrase around that. So you're using insurrection, and I hear exactly the point you're making, but Colorado's law, and I can't remember the phrase. I'm going to see if I can just scan really quickly to find it. But Colorado's law says something to the effect of there being some sort of formal finding of that status, which is the problem, right? And there hasn't been any such finding. So the court is literally inviting their own ability to assess whether Trump has done something worthy of being labeled in a certain manner according to Colorado law that has not externally been satisfied.
And that's the terrifying thing about the Colorado litigation to me is, we're now resorting to the courts to declare people presumptively ineligible to be voted for. And that's a core legitimating function of elections and of our society, the belief that somehow we get to choose who will govern us. And now we've got people going to the courts to subvert that, saying that we should be able to decide that this person is ineligible without a judicial finding. And that to me is sort of shocking and deeply concerning. I wonder what will happen across vast parts of the country if Donald Trump, a person many people want to vote for, is declared ineligible for office on the say-so of some state official. That to me is a threshold we've never crossed in the United States. And
isn't that a generous description? A state official? I mean, this is a judge. This is someone responsible for presumptively saying what the law is, not necessarily, and especially in these scenarios, this is uncharted water. And I think my issue is exactly, it's sourced exactly from what you just said. I was thinking this morning while I was reading this case that how many Colorado citizens support Donald Trump? How many people in Colorado voted for Donald Trump in the 2016 election? And how many of those voted for Donald Trump in 2020? And how is it then that this judge is inviting this sort of power to analyze whether a former president and widely respected and supported candidate for an upcoming federal election is lawfully able to be included as a name on that state's ballots when it comes to allowing those citizens access to the federal elections process? It is mind-boggling.
The wheels are popping off the cart, folks. That's, I think, what we're trying to tell you with respect to the 2024 election. We predicted it would be a wild ride. We didn't foresee this turn in the road, but let's keep an eye on that Colorado suit, because if we've got courts declaring at the urging of private parties that some candidates can't run because of their prior conduct, absence of judicial finding, we've reached a point that is one step removed from out-and-out violence. That would be state-sanctioned violence of a shocking sort, saying that your candidate can't run because we don't like what he did. There's been no finding of guilt, no hearing, simply an ad hoc sort of judgment. Kind of shocking, but it's kind of where we live in this, the best of all possible worlds in 2024. Tomorrow, we might have the courage. I'm not promising we might wimp out, but we might have the courage to talk about Israel and Hamas and the digital imperative to say yes, no, yes, no, yes, no, yes, no, yes, no. Nuance matters, and there is a crisis brewing in the Middle East, and that crisis could spill over and have worldwide consequences. What we do know is that Hamas engaged in a brutal, shocking, and savage attack on the state of Israel. Israel's right to respond is now the focus of world attention, and the notion of limited warfare, of proportionate response, a staple of international law, is under scrutiny. What can Israel do to defend itself? What is your response? What is our response? How should the world react to the savagery in the Middle East right now? I'm not sure I have answers to that. Mike and I have been kicking it around with a growing sense of unease privately. Maybe we'll take our discussion public tomorrow and ask what you think.
I think that this may be a great opportunity, Norm, to expand on the conversation as to social media use.
Yeah, I think that's right.
Because this is the exact sort of incursion on one's personal timeline that I'm talking about, right? The sheer weight and density of the Israel-Palestine war in our consciousness is something that we have never before experienced with this level of efficacy. And that is the issue to me, larger, and without minimizing anything. We will have the courage to talk about it, and we will. But I'm going to allow my thoughts to sort of consolidate around the proposition that perhaps this is the best illustration we could have, the best opportunity we might have to better diagnose the problem of social media use in America.
So let's end on a light note. I'd like to address a couple anonymous haters who were making sport of apparently my less than photogenic appearance with Owen Schroyer on a fundraising pitch we made for him as he turned himself in. And one put an image of me up on a screen and said, "If your lawyer looks like this, you're going to jail." And one of his half-wit compatriots said, "I'm surprised they don't have his picture on a carton of 2% milk." To that particular hater, they didn't do that because they were afraid that my image was so ugly it would turn the milk to cottage cheese and you would eat it. So go fuck yourself. It's safe sex. Enjoy your day. We'll see you tomorrow on Law and Legitimacy.
See you tomorrow, Norm. You guys know how to find us.